This is a public meeting of the Commodity Futures Trading Commission to consider interpretive guidance and policy statements regarding compliance with certain swap regulations, or what we call cross-border guidance, and an exemptive order regarding compliance with these provisions, or a phase-in of these provisions under Dodd-Frank. I'd like to welcome members of the public, market participants, members of the media, as well as those listening to this meeting on the phone or watching the webcast. This is our 30th meeting to implement Dodd-Frank, and I would like to thank Commissioners Chilton, Ouen, and Ouen for their significant contribution to the efforts here today, as well as their efforts over the 3 years since Dodd-Frank passed. I do note, after Commissioner Summers' long and very dedicated service, that she is not with us, and they've rearranged the chairs. And I see Commissioner Ouen, you're back on my right.
I've always been here on your right.
Yeah, I know. It feels good. And I've got Commissioner Chilton on my left, and Commissioner Ouen on my far left now. So it's good. It's good. I wonder who arranged this seating. But this meeting is just shy of the third anniversary of President Obama signing the Dodd-Frank Act. And the law was historic. And it was a historic answer to an historic problem, the near collapse of the American economy, driven in part by the unregulated derivatives marketplace. Congress and the President were clear in their intention to bring transparency to this marketplace, to lower risk to the public, and ensure that the regulation of swap dealers and major swap participants. And in 2008, when both the financial system and the financial regulatory system failed the public, Americans paid the price with this crisis, with their jobs, their pensions, and their homes. We lost 8 million jobs in that crisis, and thousands of businesses shuttered. The swaps market was one of the central features of the crisis, and financial institutions operating complicated swaps businesses in offshore entities nearly toppled the economy. Congress responded. Americans are remarkably resilient, but the public really does expect us to learn from the lessons of the crisis. I think that they expect us to do everything possible to prevent this from happening to any of us again. And it's really pretty straightforward. I think even though we oversee here at the Commodity Futures Trading Commission a complex and sometimes difficult to understand market, my mom consistently asks me, Gary, what are swaps? But the questions the American people are looking for us to answer really are, have we lowered risk? Have we brought about transparency to these markets? Have we promoted competition and openness in these markets so that end users can get the greatest benefit when they seek to lower their risk and focus on what they do well, is employing people, innovating, and moving our economy forward? That's why reform matters. 5 years after the crisis and 3 years after Dodd-Frank passed, market participants are coming into compliance with common sense reforms that Congress and the President laid out. Through Dodd-Frank and the rules that this agency has been able to put in place, no longer will the markets be closed and dark, and we will have transparency in the markets. In fact, throughout this year, for the first time, the public and regulators have benefited from reporting to data repositories and reporting to the public. And later this year, starting actually in August, facilities called swap execution facilities will start so that the public can benefit from greater openness and competition before the transaction occurs. And by the end of this year, there is likely to be trade execution mandates for interest rate and credit derivative index products as well. The broad market has moved into central clearing earlier this year, with key phase-in dates later this year as well. And we have 80 swap dealers, and yes, 2 major swap participants now provisionally registered. And with this new oversight, they're responsible for sales practice, record keeping, and other business conduct that helps lower the risk to the public. Yesterday, we stepped forward and did another significant step when the European Commission and we announced a path forward regarding joint understandings with regard to cross-border derivatives. And I want to publicly thank Commissioner Barnier, his Director General Jonathan Fall, and all of their staffs and the staffs at the European Securities Market Authority and Stephen Moyur's leadership for the constructive collaboration throughout the reform process. We have different cultures and different political systems, and we're at times at different stages of development of reforms, but I think this was a significant step forward in harmonizing and giving clarity to the markets as when there might be jurisdictional overlaps with regard to this reform. Today, we are considering 2 important actions, the final guidance as well as an exemptive order. And as you've probably heard me say, I recognize many of you here in this audience, the nature of modern finance is that financial institutions commonly set up hundreds, if not thousands, of legal entities around the globe. In fact, the U.S.'s largest banks each have somewhere between 2,000 and 3,000 legal entities around the globe. Some of them have hundreds of them just in the Cayman Islands alone. We have to remind ourselves that the largest banks and institutions are global in nature, and when a run starts on any part of an overseas affiliate or branch of a modern financial institution, risk comes crashing right back to our shores. Or in the other direction, if it's an EU financial institution and it has some guaranteed affiliate in the U.S. or overseas, that risk can go back as well to their shores. And that's why together in this path forward yesterday, both Europe and we recognize the importance of covering guaranteed affiliates, whether they're guaranteed affiliates of a U.S. person or of an EU person. There's no questions, to me at least, that the words of Dodd-Frank addressed this when they said that a direct and significant connection with activities in or effect on commerce in the United States covers these risks that may come back to us. And I want to publicly thank Chairman Barney Frank, who he and his staff, along with Spencer Bacchus, Frank Lucas, and Colin Peterson's staffs, reached out to this commission and reached out to the public to ask what was the best way to address this in statute, because they understood that risk can wash back to these shores. Lest we forget AIG that nearly brought down the U.S. economy. Lest we forget Lehman Brothers and its 3,300 legal entities, including a London affiliate that was guaranteed here in the U.S. and had 130,000 outstanding swap transactions. Lest we forget Citigroup, that its structured investment vehicles were set up in the Cayman Islands, run out of London, and yet we're at the center of the bailout, not one bailout, but 2 bailouts of that institution. Lest we forget Bear Stearns that started us on this path in 2007, that had 2 sinking hedge funds that had to be bailed out by Bear Stearns. And yes, those hedge funds were organized in the jurisdiction of the Cayman Islands. A decade earlier, I happened to be I'd say somewhat lonely Assistant Secretary of the Treasury and making a call to then Treasury Secretary Ruman from Connecticut to report that long-term capital management's $1.2 trillion swaps book was not only going to go down within a day or two, and though I was in Connecticut and sure thought that's where this business was operated and run, it was incorporated in the Cayman Islands in a P.O. Box facility. Lest we forget, even last year, the reminder that branches of big U.S. banks can bring risk back here, and though they were not the risks as large as I've just relayed, J.P. Morgan Chase's chief investment officer credit default swaps were executed primarily in the UK branch. Each of these examples clearly had a direct and significant connection with activities in or effect on commerce in the United States. Congress knew this painful history when it crafted the cross-border provisions of swaps market reform, and as market participants asked the CFTC to provide interpretive guidance on Congress's word, we too, I believe, have kept this painful history in mind. And at the request of market participants, and yes, it was at the request of market participants 2.5 years ago, the CFTC started working on guidance, which was published for notice and comment last June, which we went out for further questions on in December. And I think we have greatly benefited from that public input. But I think the guidance between the commissions before us today adequately addresses those comments, those concerns, and I think appropriately interprets these key provisions of Dodd-Frank. And if I could just say 4 areas that I think really are important, that the requirements do cover swaps between non-U.S. swap dealers and guaranteed affiliates of U.S. persons, as well as swaps between 2 guaranteed affiliates that are not swap dealers. In essence, the issue of risk importation. The guidance does, as was proposed, recognize and embrace the concept of substituted compliance where there's comparable and comprehensive rules abroad where they exist. But the history of AIG, Lehman Brothers, Citigroup, and the others, and the guaranteed affiliates, I think is a strong lesson that Congress knew when we were approaching these issues. Secondly, the definition of U.S. person in this guidance captures the offshore hedge funds and collective investment vehicles that have their principal place of business here in the U.S. or majority owned by U.S. persons. Addressing ourselves to guidance and yet forgetting the lessons of long-term capital management or Bear Stearns, I don't think is what Congress wanted, and I'm pleased that the staff's recommendation includes coverage of these types of entities. Under the guidance, also foreign branches, like the J.P. Morgan's UK branch of U.S. swap dealers, possibly may also comply with Dodd-Frank through substituted compliance. I think we looked very closely at this, took a lot of public feedback, and have appropriately ring-fenced that it's truly in a branch where employees and the booking and the taxes are truly offshore in a branch, but this allows, if there is comparable and comprehensive regimes overseas and supervisory authorities overseas looking at those branches, that those branches as well can avail themselves to substituted compliance as offshore guaranteed affiliates would as well. And lastly, that swap dealers, foreign or U.S., transacting with U.S. persons, whether they be in New Jersey, Maryland, Michigan, Arkansas, Iowa, I have to get all the right states, anywhere really in the United States, they comply with Dodd-Frank swaps market reform. The guidance does provide, though, that U.S. persons can meet international people anonymously on not only our exchanges called designated contract markets, but also on the new swap execution facilities, as well as foreign boards of trade, and that international people can look to those trading platforms rather than concerning themselves or getting caught up in counting towards a swap dealer definition or the rules of Dodd-Frank. And I think that that was important to maintain and promote the liquidity of these 3 very important types of platforms: foreign boards of trade, swap execution facilities, and designated contract markets. In conclusion, I will be voting in support of the guidance and the exemptive order today. I'll say more about the exemptive order. But I think these are critical steps. They add to the nearly, I think it's 56 final guidances and rules that this commission has adopted. We're well over 90% through the various rule and guidance writing. The markets are probably well towards halfway implementing these markets, and I have a deep respect for how much work market participants are doing to come into compliance. With that, I think I'm going to turn it over to Commissioner Chilton.
Thank you, Mr. Chairman. And yeah, we've done a whole lot. And, because of your leadership, we've done a whole lot. And we've done all these rules. But without what we have the possibility to do today, it won't reach its full effectiveness, everything that we have done. I'm just saying, it won't matter as much if we don't do this thing, if we don't provide the guidance with the phased-in effective dates. Just saying. So I think it's really critical. And the reason it wouldn't be effective is as effective as it should, these other rules, is because, of course, we're an interconnected, interrelated, interdependent, a bunch of markets. And there's more commonality of connections in the financial world than ever before. And so we learned that, as you say, Mr. Chairman, risk is click of a mouse away, can shoot all around the globe. And that came home to roost in 2008. So my takeaway for the things that we can do here today are twofold. One, we can add certainty above everything else. That's what people have said. Just give us the rules. I mean, we want them done appropriately, but give us the rules. Let us know. Let us know. We don't want to be hanging out there any longer. So this provides certainty, and it provides a financial regulatory structure in a changing world with morphing markets. And the second thing that it does is that it's more cognizant of what's going on outside of our little universe here in the States, because these are interconnected markets. And that's why the phase-in of the effective dates is so critical. I don't think I could support this thing without it. And so we've worked a lot, and I appreciate the effort of all my colleagues in this regard. And I think we've come to a good place where this will result in more harmonized global regulations. A couple of times I've talked about, the movie Field of Dreams, where Kevin Costner hears the voice from the cornfields. Anybody? No, nobody saw Field of Dreams. And the voice says, "If you build it, he will come." And that's how I view what we're doing here and what the European Union is doing. If we build it, and if the EU builds it, that the rest of the financial world will come. The rest of global regulators will come. They'll have similar and more harmonized regulatory regimes. And that's good not just for individual countries. It's good for the world. It's good for consumers. It's good for our economies. The last point I wanted to make is that I know there's a lot of naysayers out there, and, we shouldn't do this, we couldn't do this, we didn't have enough time, we didn't do this. But look, the economic collapse was in 2008. Dodd-Frank was 2011. Dodd-Frank mandated that we do this stuff by 2011. The G20 agreed that we should have the swaps reforms in place by December of 2012. As the chairman said, we've had this guidance out there for a long time. It's been hanging around in various forms. It didn't just sneak up on us. It's been here. And so, we shouldn't have any regulophobia. Paranoia will destroy you. So, one of the things, out of an abundance of caution, that famous Washington phrase, right, out of an abundance of caution, we have inserted, and I am really pleased with this, the comment period for 75 days. And it's not window dressing. It's not a whip-de-doo. We need it. We want it. We got to have it. And I look forward to receiving comments and listening to them carefully. And if we have left a thread hanging loose, if we got some kinks that we got to work out, then we can address it. Finally, I just wanted to thank the chairman, truly, Gary, for your leadership on this. I mean, the thing with the EU is just miraculous, very critical and important and time-sensitive. But all of your leadership has been just exemplary, and I thank you. It's an honor to work with you. But that also goes for Commissioner Summers, who we miss, and Commissioner O'Malley, and Commissioner Ouen, who's always thoughtful and has been very thoughtful in the last couple of days, spending hours and hours on this. And I really do consider it an honor and personal privilege to work with each of you. And then finally, and your staffs, by the way, who, I mean, this has got to be the most complicated guidance, the most complicated thing we've done in the 3 years, at least from my experience. And all of our staffs have done just a super job. So thank them. And then finally, the professional staff at the table and behind you and some up in your offices watching. Just a mammoth undertaking. I couldn't thank you more. I can't thank you more. And I think the right thing to do is to honor your tireless work by approving this thing today. If we don't do so, it means that we go back to having markets that are unprotected and consumers and our economy is unprotected, and that's not the right thing to do. Just saying.
Thank you, Commissioner Chilton, very much. Commissioner Malia, welcome back from vacation.
Thank you to the staff and my fellow commissioners and obviously the international regulators for all the hard work that they took to get here and to develop this document. But first, I'd like to say a few words. Despite the elaborate confusion of the chairs in order to cover up Jill's absence, it is important we do recognize her, as the chairman and Commissioner Chilton have done. She was obviously our ambassador to the international regulatory body for a number of years and did an outstanding job working through these international issues, led the GMAC. She was very disciplined, careful, thoughtful, and knowledgeable. And most recently, she led the successful investigation of the MF Global, which I think we'll all be thankful for as that proceeds. So I do want to recognize her, and we'll certainly miss her. And it leaves not only a hole at the table, but a hole in the policy debate when you have somebody as experienced as Jill Summers not participating in this discussion about cross-border regulation, which she has so much experience in. So, again, thank you to the staff and the Commission and obviously the international regulators for all the work to modify the cross-border document and the attendant exemptive relief and no-action letters that enable us to avert the regulatory train wreck that might have had occurred had we not engaged our European colleagues in these last-minute negotiations. While the agreement is far from perfect and requires extensive no-action relief, I will take away the positive experiences from this process, which is obviously to validate the ability and the desire to harmonize our rules with home country regulators who have the same goals and, in fact, many of the same rules as the U.S. does. Mr. Chairman, as you well know, I've consistently advocated for close engagement between the full Commission and fellow regulators to harmonize our rules. And in my discussion with the various international regulatory bodies, it's clear to me that the varying degrees of reform that are comparable, some are less, but some are also exceed our own rules. And I would have preferred that the Commission take the past year following the release of our proposed guidance that Commissioner Chilton noticed it was hanging around for the past year, to actually sit down and engage international colleagues and possibly engage IOSCO to determine how we could harmonize our rules and really engage in that substituted compliance determination that we're going to put after the rulemaking or after the guidance process, not before. But if we had done this in reverse, we could have put in place guidance that would have filled the gaps with the holes that we have recognized, taking into account where there may be shortcomings. Instead, we have chosen to impose statutorily weak guidance with all of its no-action riders and exemptions with the promise of further negotiations. Given this process, however, it is my hope that the work lying ahead will be undertaken in a more transparent manner and not done through the abused no-action process that lacks any formal Commission process or rigor. And further, I hope that this process of substitute compliance will offer the opportunity for other regulatory bodies to engage directly with the full Commission so that we can better understand how our rules and theirs will work and we can minimize the likelihood of regulatory retaliation, inconsistency, and duplication. I believe the Commission has worked too hard to develop the principles and the standards that will encourage greater transparency, open access to clearing and trading, and improved market data. I want to work with other home country regulators to ensure that there is not the opportunity for entities to exploit regulatory loopholes. The stark reality is that the Commission is not the global regulatory authority that it may think it is, and it does not have the resources to support such a mission. Therefore, our best and our most effective solution is to engage in a fully transparent discussion in the substituted compliance and to do so immediately. When I voted in 2012 to issue for public comment the proposed guidance, I made it clear that if if I had been asked to vote on the proposed guidance as final, my vote would have been no. I then laid out my concerns relating to the Commission's unsound interpretation of 2I of the CEA, which governs the extraterritorial application of the CEA's swaps provisions. Regrettably, the final guidance fails to address these concerns, as I have discussed, and it represents a regulatory overreach based on a weak foundation of thin statutory and legal authority. Just as the proposed guidance, the final guidance misinterprets Section 2I of the CEA as inconsistently implied in different activities and blurs the lines between interpretive guidance and rulemaking, and gives insignificant consideration to international law and comedy. Section 2I of the CEA, as amended by Dodd-Frank, provides in part that the Commission's swap authority shall not, quote, shall not apply to foreign activities unless these activities have a direct and significant connection with activities in or effect on the commerce of the United States, end quote. This provision is clearly a limitation on the Commission's authority, and it follows that the Commission must properly articulate how and when the direct and significant standard is met in order to apply the Commission rules to swap activities that take place outside the United States. The final guidance, however, fails to do so. Instead, it treats Section 2I as a ready tool to expand authority rather than as a limitation. And the statutory analysis section of the final guidance is insufficient, relying heavily on a comparison with other statutory language whose wholly indifferent context renders the comparison useless. Because the proper foundation for the standard has never been laid, the rest of the document includes sporadic references to direct and significant without explaining or justifying the various requirements being placed on market participants. In an effort to mitigate the broad reach of the guidance and in a moment of humility, the Commission will agree to delay the application of certain agreement elements of the swap regulation, largely to accommodate the last-minute finalization of this guidance. The exemptive order, in broad terms, provides relief ranging from 75 days to apply the expanded U.S. persons to December 21st for entity-level and transaction-level requirements for U.S. swap dealers in specific jurisdictions, as well as further extensions for transaction-based rules. In its failure to address this matter earlier, the Commission has included a 75-day comment period on the exemptive order, seemingly as an acknowledgement of the Administrative Procedure Act, but clearly not in compliance with this binding federal statute. I support the additional time to allow market participants to comply with the last-minute guidance, but I cannot support a final order that blatantly ignores the statutory required comment periods for the Commission for Commission action, especially when I advocated for a relief package that would have provided for public comment over a month ago. Mr. Chairman, I've prepared a more thorough dissent that I ask that be included in the Federal Register and the record of this meeting. Let me close by thanking the staff again and the Commission and our fellow international regulators for their cooperation in avoiding regulatory disaster that should have never been contemplated, let alone narrowly averted. I will look forward to a more transparent and inclusive discussion between the Commission and other home country regulators to harmonize our rules before the next deadline of December 21st. Thank you.
Thank you, Commissioner Amalia. Commissioner Weecham, before I turn over, I just want to thank you particularly for all that we've done together on this guidance. I think it is far better given the many hours that we've spent since last June and July. Some people in the media have focused on this week, but I can't imagine how many hundreds of hours you and I have spent together. But I knew we were going to make a breakthrough when earlier this week Commissioner Weecham shared with me his own nicknames for his staff. And I knew that's when we were absolutely where we're going to get to this day. So I thank you. I'm not going to share those nicknames, but, you know, it's up to you, Commissioner Weecham.
I've embarrassed my staff enough. Thanks, Mr. Chairman. And forgive me for my cough, but I'll try and get through the statement here. Several weeks ago in London, as the Commission intensified discussions on a number of cross-border issues, I spoke about 3 key objectives that must be achieved in a workable cross-border framework. First and foremost, I said that the Commission's cross-border policy must protect U.S. taxpayers and the stability of the U.S. financial system. Second, I said it must embrace a substituted compliance approach that supports an efficient and sound derivatives market structure, while also ensuring a level competitive landscape for the firms operating within it. And finally, I said the cross-border guidance must be clear and workable. I am confident that the guidance and exemptive order before us today will adequately meet these objectives. I am therefore prepared to support them. Risk associated with derivatives is mobile and can migrate rapidly across borders in modern financial markets. All of us have observed that while financial activities abroad may be confined to local markets, the rights and responsibilities that flow from these activities often are not. In light of this fact, in reaction to the financial crisis, Congress authorized the Commission to oversee activities conducted beyond U.S. borders in appropriate cases. Congress was purposefully less clear about what the appropriate cases might be, leaving it instead to this Commission to make those judgments. The guidance makes rational policy judgments about what those appropriate cases are today. The foreign branches of U.S. banks operating overseas and other foreign entities benefiting from the credit support of a U.S. firm will be required to register if they are active dealers in the swap markets. With registration, of course, the public is assured that such entities implement risk management programs, report their swap activities, abide by capital standards, and manage credit risk in compliance with margin and clearing requirements. I noted in London that it is paramount that the Commission seek to achieve its regulatory objectives in a manner that respects the limits of U.S. law and the resource constraints of U.S. and global regulators. I acknowledge then, and I acknowledge now, that the Commission must tread carefully with respect to activities occurring solely on foreign soil, especially those involving only foreign firms or foreign affiliates of U.S. firms. I am persuaded, however, that affiliates benefiting from the financial support of a guarantor in the aggregate do carry the potential to directly and significantly affect the health of the U.S. financial system. In many credit arrangements, risk flows directly back to the U.S. firm providing the guarantee. I think it appropriate for the Commission to seek to contain the risks associated with swap dealing where those activities occur. In many cases, the guarantor itself is prudentially regulated. That might argue in favor of simply applying additional risk regulation to that entity. Prudential regulation, though, has taken into account risk importation issues for decades. It alone has not always prevented risk management failures and the resulting threats to the stability of the financial system. The guidance therefore brings guaranteed affiliates within the Dodd-Frank regime. It also takes the practical approach of allowing that non-U.S. affiliate to abide by risk management practices required by the jurisdiction in which it is located, so long as the Commission deems those practices comparable to U.S. law and sufficiently comprehensive. This approach strikes an appropriate balance between asserting the Commission's regulatory interests and recognizing the interests of other regulators. The swap markets, as we all know, are global. The guidance therefore supports an efficient and sound market structure by permitting U.S. persons to trade and clear swaps with non-U.S. persons through markets and clearinghouses outside the U.S., so long as they are regulated in a manner that is essentially identical to Dodd-Frank. This enormously consequential policy adjustment translates to open, competitive derivatives markets. It will mean efficient and liquid markets. A global regime such as the one now contemplated in the guidance is the best means to avoid balkanization of risk and risk management that would have benefited no one. In fact, the fragmentation and regionalization of markets that I believe likely would have developed under the earlier proposals also would have exposed the U.S. financial system to risks that are unnecessary, needlessly complex, and difficult to predict and contain. I want to thank Chairman Gensler for his flexible thinking on this particular topic during the past several weeks. Indeed, perhaps more than any other policy decision in this guidance, the Commission's resolution of this important policy issue best explains the accord we just reached with the Europeans on the cross-border regulation of derivatives. There are two technical points I would like to mention, however. First, while I support the practical outcomes of the no-action letters that allow Eurex and LCHSA to clear U.S. dealer swaps pending completion of their applications to register with the Commission, I believe this relief should have been delivered through formal Commission action. Likewise, the no-action letter that finds the various risk mitigation requirements under EMIR to be essentially identical should have been a Commission action. In the future, I expect these determinations will receive the full input and legal force of the Commission. Second, while for now we are requiring the European clearinghouses or foreign boards of trade to register with the Commission, the final guidance contemplates a mutual recognition framework in which trading and clearing venues may compete fairly for U.S. business if they operate under essentially identical regimes. For instance, in the European Union, it is expected that European law will soon provide for the registration of new trading venues called organized trading facilities. The Commission will have the flexibility under the guidance to examine the requirements applicable to these new platforms and determine whether they are essentially identical to U.S. law and therefore suitable for U.S. participants. Similarly, the guidance clarifies that such trading venues may register as swap execution facilities or petition for recognition as exempt CEFs. Toward this end, the Commission should undertake a rulemaking soon to implement a petition process for regulated trading venues abroad that might seek recognition as exempt CEFs. The Commission staff is also developing a rulemaking to govern the process for recognizing exempt DCOs. In addition to providing for an efficient market structure, the guidance avoids creating unfair advantages for certain firms over others, or for certain legacy business structures over others. The guidance now reflects the policy that if the activities of and risks presented by firms or business structures are not materially different, the Commission will not treat such firms or business structures differently. Foreign branches and guaranteed affiliates that are registered dealers will abide by the same policies under the same circumstances. For markets to operate efficiently, competitively, transparently, and safely, market participants must know whether U.S. law applies, whether U.S. law conflicts with the laws of foreign jurisdictions, and whether they are doing what the law requires. Based on the Commission's joint statement with the European Union yesterday, together with the Commission's documents today, market participants now should have a good understanding of the rules of the road for conducting swap activities on our two continents, which continue to host the vast majority of swap activity globally. Although some called for more time, the Commission was not in a good position to delay these policy judgments any longer. Global market participants deserve regulatory certainty, and today's guidance and exemptive order provided. This week's accord with our friends and partners in Europe, moreover, empowered the Commission to adopt this policy even before the important work of delivering on the G20 commitments was complete on that continent. Inevitably, there will be questions arising from the guidance and exemptive order and perhaps issues unaddressed in these documents that should have been. But I am convinced that in some, the most important questions have been answered clearly enough for now. Finally, and based on today's facts and circumstances, the exemptive order provides sufficient adjustment time for the marketplace and appropriate incentives for foreign regulators to bring their regimes in line with Dodd-Frank. It could turn out that these compliance dates are too aggressive with respect to certain requirements. In that case, the Commission must listen and respond to market participants and other regulators who bring legitimate compliance challenges to its attention. Again, I want to thank the Chairman for his flexibility and tireless work over the last several weeks. It was only a short while ago that I publicly expressed skepticism that the Commission would be able to finalize these documents today. The Commission was able to pull off this impressive feat under a relatively truncated timeline. How's that for an understatement? Only because of the Chairman's leadership and consensus building. And I want to thank the Commission's professional staff who have worked day and night to bring the guidance and exemptive order over the finish line today. I appreciate your efforts, and the American public owes you a debt of gratitude for the important service you have provided that is now reflected in these important policies. Thank you very much.
Thank you, Commissioner Ouen, Commissioner Amalia, and Commissioner Chilton, for all of your input. And I just want to say, Commissioner Amalia, though it doesn't sound like today you'll be able to support this, your input throughout this 14 months has been so valued, and I think the guidance is better for that input, even if we weren't able to bridge the gap. Before we turn to the staff to present, I want to just turn to one other item, which is important. I hope this is all right. But at this point, I'd like to just raise an issue with Commissioner Summers not being with us now, a matter of the leadership of the Global Markets Advisory Committee, or what we sometimes call GMAC here. We have a number of advisory committees, as you may know. Commissioner Amalia has shown great leadership on the Technology Advisory Committee. Commissioner Summers did so on the Global Market Advisory Committee, but now with her no longer being a commission, I'm pleased to announce today that Commissioner Chilton will be taking on her responsibilities. And under the charter of the Global Markets Advisory Committee, the Commission must vote on the designation of Commissioner Chilton as what's technically called the sponsor of this advisory committee. So I would entertain a motion to designate Commissioner Chilton as the sponsor.
Before we start that, can I ask a question of Commissioner Chilton on his priorities for the GMAC, and now that we have the important substitute compliance requirements before us, we have a vague process, but it certainly could benefit through a formal, open, transparent process which invites foreign regulators, home country regulators, to participate in defending their regulatory regimes before the Commission, the Commission, not the staff, but the Commission makes a decision on this. Are you going to put that on the agenda as an immediate objective?
Yeah, we spoke about it briefly before the meeting, and I think it's a super thing that we should do. I mean, this substituted compliance isn't going to be something that we look at one time, take a snapshot, and then call it quits. It's going to be an evolving and a morphing thing, and I think the GMAC can play a really important role in that regard. In general, these markets are changing so fast that we need to think anew about them, and so I look forward to doing that with my colleagues, but with the GMAC. I mean, it's really an epic endeavor in which we're involved here. We've never done anything like this before globally. So, yeah, we'll do that, Commissioner O'Malley, and we'll do a lot more, too.
Well, I'm happy to move his nomination.
Second.
And I am delighted and support Commissioner Chilton filling the big shoes of Commissioner Ouen, though, on this. So do I do it? Do I hand it to you, Melissa, or do I do it? I hand it to you. Thank you.
This is a vote on the designation of Commissioner Bart Chilton as the sponsor of the Global Markets Advisory Committee. Commissioner Ouen?
Aye.
Commissioner Ouen, aye. Commissioner O'Malley?
Aye.
Commissioner O'Malley, aye. Commissioner Chilton?
Aye.
Commissioner Chilton, aye. Mr. Chairman?
Aye.
Mr. Chairman, aye. Mr. Chairman, on this matter, the ayes have 4, the noes have 0.
We have matters of 2 other advisory committees as well, and with all respect, I'm just going to go through those as well, and because that's where we are. But I want to say we're also considering establishing a new advisory committee to be headed by Commissioner Ouen, and it's to be named the Market Risk Advisory Committee. We're not able to take a vote today because we're working with the General Services Administration Committee Management Secretariat to approve this new committee. But I think that we will greatly benefit as a commission by pulling together a group of outside individuals of diverse backgrounds to give us advice on broad issues of market risk. But I thought I'd just turn to Commissioner Ouen if he wanted to say any comments. There's not actually a vote, but just...
I just appreciate your support, Chairman, in our discussions about this advisory committee, your willingness to consider the creation of a new one, And also want to thank the folks in OGC who have been advising me on how best to go through this process, and we're hoping to get this up and running very soon. Thank you.
I think you'll do a great job at this, Commissioner Weegen. And one of the things I talked about back in April was listening to end users more, and I suggested we do an end users advisory committee. But really, the effort of what we're looking at with an end users advisory committee can be consumed by the risk committee, because it's all about risks. So I look forward to working with you on the end user component, which I know you care deeply about also as part of your work with that advisory committee.
And just so I can finish the trio here, our Agricultural Advisory Committee will meet in this room on Thursday, July 25th from 9 a.m. Till the early afternoon. The committee is now, though I am technically the sponsor under the charter, and I'm proud to be the sponsor, the committee is chaired by Dr. Randall Fortenberry. We look forward to that meeting. Now, with that, I think it is time for me to turn over to the excellent. I have to do page 3. I'm apparently told I'm supposed. The staff will make presentations concerning their recommendations on the cross-border guidance and cross-border phase-in exemptive order. After each presentation, the floor will be open for questions and comments from each of the commissioners. Following these discussions, the Commission may take votes on the recommendations as presented. All final votes conducted in this public meeting shall be recorded votes. The results of these votes will be included in their relevant Federal Register release, including your longer piece. I first just ask unanimous consent to allow staff to make technical corrections to the document voted on today prior to sending them to the Federal Register. Without objection, so ordered. And then at this time,
Mr. Chairman,
sorry.
On the technical corrections, we talked about this a little bit. There might be a number of them, given the short time frame that we've had to have the staff draft all this up. So we look forward to continuing to work with the staff, and we'll get those. We'll get changes based on our review that reflect the agreement to the staff as quickly as possible.
Absolutely. And so for the public, that means, though we normally do put these things on the website today, if one of the documents goes on the website and the other doesn't, and it's over the weekend or so forth, you'd understand. We just want to make sure that it's technically exactly what we have. I mean, we all have a voting document from last night, and my review is I think that that's pretty much there, but of course we want to make sure. And everybody will see that. At this time, I'd like to welcome Jonathan Marcus, our General Counsel, Carlene Kim, Deputy General Counsel, Laura Badian, off from the Office of General Counsel, Sarah Josephson, our Director of Office of International Affairs, Gary Barnett, who runs our Division of Swap and Intermediate Oversight, Eric Remler, who's the Deputy Director, to present their thoughts and recommendation on cross-border. Before I do, I just want to thank not only the 6 of you, but probably the couple of dozen or 3 dozen other people that for these last really 18 to 20 months of thinking through these issues have just put an enormous bit of dedication, energy, and thought into this, including many late nights this week. So thank you.
Good morning, Mr. Chairman and Commissioners. Today, staff is recommending that the Commission approve interpretive guidance and policy statement regarding the cross-border application of the swaps provisions of Title VII of the Dodd-Frank Act. First, before we get into the details, on behalf of my colleagues in the Office of General Counsel, I would like to thank staff in the Division of Swap Dealer and Intermediary Oversight, Office of International Affairs, Division of Market Oversight, and Division of Clearing Risk for all of their hard work, advice, and support during the drafting process. My special thanks goes to Mark Pfeiffer and Laura Badian in the OGC office for their exceptional dedication and hard work in bringing us to here today. And I would be remiss if I did not acknowledge the special contributions of Dan Berkovitz, Jackie Mesa, and Terry Elbit. They're no longer with the agency, but each played a critical role in developing the guidance. This interpretive guidance and policy statement is intended to provide greater legal certainty and clarity to U.S. and non-U.S. market participants regarding their obligations under the Commodity Exchange Act with respect to their cross-border activities. In particular, the guidance addresses the circumstances under which a non-U.S. entity would be required to register as a swap dealer or MSP, and the extent to which Dodd-Frank requirements would apply to such registrants. It also provides a general framework for a substituted compliance regime under which the Commission would permit a non-U.S. registrant to comply with comparable and comprehensive requirements in its home jurisdiction. The guidance also addresses the extent to which Dodd-Frank provisions would apply to transactions between non-registrants. I'll now pass the microphone to Laura Badian, who will describe the key elements of the guidance.
Good morning. Thank you. Let me first turn to the interpretation of the term U.S. person, a foundational element of the guidance. As proposed, the term was intended to encompass those persons whose activities, either individually or in the aggregate, have a direct and significant nexus to U.S. commerce within the meaning of Section 2I. In addition, the term U.S. person is a useful concept when considering the extent to which U.S. transactional level requirements should apply to swap transactions. The term U.S. person is largely territorial-based. The definition would include natural persons that are U.S. residents, as well as corporations, business entities, and funds that are organized in the United States or have their principal place of business here. In addition, collective investment vehicles, such as hedge funds and commodity pools, are included in the interpretation of the term U.S. person if they have their principal place in the United States. Such collective investment vehicles or funds also would fall within the term U.S. person if they are majority owned by U.S. persons, but there is an exception for collective investment vehicles that are publicly offered but not offered to U.S. persons. Turning to the Dodd-Frank requirements, for purposes of applying the swap provisions of the Dodd-Frank Act to cross-border swap transactions, the guidance divides these requirements into two basic categories. First, entity-level requirements apply to a swap dealer or major swap participant firm as a whole. For example, entity-level requirements would include such things as capital adequacy, chief compliance officer, and swap data repository reporting. In contrast, transaction-level requirements generally apply on a transaction-by-transaction basis and include, for example, clearing, margin, real-time reporting, and trade execution requirements. Transaction-level requirements generally apply to swaps between non-U.S. swap dealers and MSPs with U.S. persons and with guaranteed affiliates. But these swaps would generally be eligible for substituted compliance. Dodd-Frank, in the case of swaps with guaranteed affiliates. Dodd-Frank Act transaction-level requirements generally do not apply when the swap is between a non-U.S. swap dealer or major swap participant and a non-U.S. person that is not a guaranteed affiliate. Where a swap is executed anonymously between any non-U.S. swap dealer or major swap participant and a U.S. person on a registered DCM or SEF and cleared, the non-U.S. person generally will be considered to have satisfied the transaction-level requirements that apply to such a swap transaction. As Carlene mentioned, and many of you have mentioned, there is a substituted compliance regime set forth in the guidance. Under the substituted compliance regime, if the Commission issues a comparability determination for a given entity or transaction-level requirement, the Commission generally would permit an applicant to substitute compliance with the requirements of the relevant home jurisdiction's law and regulations, or in the case of foreign branches of U.S. swap dealers, the foreign location of the branch, in lieu of compliance with the corresponding requirement under the Commodity Exchange Act and our regulations. The guidance broadly describes the process and the factors that it would consider in making this comparability assessment. A couple of things to emphasize here. First, comparable and comprehensive does not mean that we would look for identical regulations abroad. Rather, we would take into account all relevant factors, including the scope and objectives of the relevant regulatory requirements and the comprehensiveness of the foreign regulator's supervisory compliance program when you make this assessment. Second, this assessment does not entail a rule-by-rule analysis, but rather the Commission would make this assessment on a category-by-category basis. With respect to guaranteed affiliates, the guidance recognizes that non-U.S. persons, which are affiliated with a U.S. person, may present the potential for systemic risk to the U.S. financial system because such swaps are guaranteed by a U.S. person. So, for example, swaps entered into by non-U.S. swap dealers with guaranteed affiliates of U.S. persons would be subject to Dodd-Frank Act requirements, as are swaps with U.S. persons. But the transaction with the guaranteed affiliate would be eligible for substituted compliance. Swaps between two guaranteed affiliates that are not swap dealers would also be subject to certain Dodd-Frank requirements that apply to non-swap dealers, but with substituted compliance available. A swap between a non-U.S. person and a foreign branch of a U.S. swap dealer, or between two foreign branches, is eligible for substituted compliance and is not counted towards the de minimis threshold for swap dealer registration if the swap is bona fide with the foreign branch based on factors such as whether the employees negotiating and agreeing to the terms of the swap, other than employees with ministerial functions, are located in the foreign branch or another foreign branch of the U.S. bank. Another factor would be whether the foreign branch or another foreign branch is the office through which the U.S. bank makes and receives payments and deliveries under the swap. With respect to the swap dealer de minimis calculation, the Commission's policy under the guidance is that a U.S. person or a non-U.S. person that is a guaranteed affiliate should generally count in its swap dealer de minimis calculation all of its dealing swaps, whether with U.S. or non-U.S. counterparties. However, a non-U.S. person that is not a guaranteed affiliate should generally count swaps with U.S. persons and swaps with certain guaranteed affiliates. However, a non-U.S. person that is not a guaranteed affiliate may exclude any swaps that are entered into anonymously on a registered DCM, CEF, or Foreign Board of Trade and cleared. Stated in general terms, the Commission's interpretation on aggregation allows both U.S. persons and non-U.S. persons in an affiliated group to engage in swap dealing activity up to the de minimis threshold. The swaps of an affiliate, either U.S. or non-U.S., that is a registered swap dealer, are excluded. When the affiliated group meets the de minimis threshold in the aggregate, one or more affiliates inside or outside the United States would generally have to register as a swap dealer so that the relevant swap dealing activity of the unregistered affiliates remains below the de minimis threshold.
I didn't know if there was more presentation or not. No, okay. So the chair will now entertain a motion to accept the staff recommendation concerning the cross-border guidance.
So moved.
Thank you. I support this guidance, given all that I said earlier, so I won't repeat it again. But I think this guidance appropriately balances the international harmonization efforts. What I've come to learn is this word about international comity. But most importantly, the protection of the American public and bringing transparency to these markets and the reality of modern finance, that global financial institutions guaranteed in any jurisdiction can bring risk back to that jurisdiction. And I think that's what's critical and the core of what is direct and significant connection to or effect on U.S. commerce. So I support this guidance and I also want to thank publicly the Securities and Exchange Commission for tireless and consistent input over these last 18 or 20 months of considering these issues. Commissioner Chilton?
I'm fine, thank you.
Commissioner Ouen?
Thank you. I'm very interested in the substituted compliance program on page, I think, well, I don't know what the new draft, last night's draft says, but I think one draft I had was page 208 had a statement in there there's going to be an outcomes-based, and Laura, you basically indicated that it would be outcomes-based. You didn't say those words, but is that what you meant in your summary of your description of the process?
Right, but of course, we would look to see whether the requirements in the other jurisdictions are comparable and comprehensive to ours.
So one area that I'm kind of wondering about is data reporting. As I understand it, we will require direct electronic access for in order to be, as the first test, direct electronic access without any legal barriers. Is that correct?
Yes, unfettered access.
Do we provide the same for international and the same unfettered access to our SDRs to every other regulatory entity?
I'm going to look to my colleagues in Division of Market Oversight.
Good morning.
Good morning.
Our ability to provide direct unfettered access to our foreign counterparts is somewhat constrained by the statutory provisions of Dodd-Frank, which require in Section 728 of Dodd-Frank, 21D of the CEA, that such access must be accompanied by an indemnification agreement. We have done at the staff and the commission level as much as we believe we're able to do consistent with the Dodd-Frank Act to find ways to accommodate foreign regulators where we think we can.
Now, thank you very much. Now, it also says as a second condition that we will insist on a comparable form and format of the data. Does that mean we get to dictate to foreign SDs or, TRs that they have to develop, they have to collect the same data we are and in the same format that we're collecting it in order to be comparable?
I don't know that that's strictly true, and because I'm not a data expert, I may not be able to give you the answer that you're looking for. But I think the idea is that the data has to be sufficiently comparable so that it has some utility to our surveillance staff and ODT, I forgot what the division is called, so that they can use it appropriately and so that it can be aggregated.
So I'm trying to understand how an outcomes-based and a form and format requirement is consistent, because demanding a foreign entity meet our form and format doesn't sound like an outcomes-based. That sounds like a much more granular specific. How do we reconcile these two?
It is, by definition, I think, a more technical requirement than some of the others. However, we think, and we are working with Srini and John Rogers to come up with a protocol that would allow us to say that while their data is not identical to ours, it can be made useful in some way so that it does not have to be identical.
That goes right up until we get to large trader reporting, correct? And that we will demand, there is no substituted compliance into this proposal for large trader reporting.
That's correct.
How are we going to compel non-U.S. persons to report, to comply with our large trader reports?
My understanding is, and my colleagues in DMO should correct me if I misstate anything, but my understanding is that currently non-U.S. persons do submit to the extent that they trigger reporting requirements under Part 20, they do so report.
That wasn't the question. How are we going to enforce somebody else who doesn't feel like they need to comply with large trader reporting under this guidance?
I think if Laura and Susan turn your mic off, it will help just their feedback. But now, David Van Wagner.
Yeah. I mean, the premise, of course, is the requirement in the first instance is only going to be going out to SDs and clearing members. So that's, as a threshold, you'll have to be that. And they are actually reporting this data.
So you're saying that we
already.
would use the registration as the hook to compel them to report?
I think that's right.
But it doesn't, the large trader language doesn't, I think it's on I don't know what it is on. 236. It says for non-U.S. persons. It doesn't limit it. And there's a variety, forgive me, there are a variety of different large trader references sprinkled throughout this document that it's tough to understand.
Granted, but the overlay, of course, is Part 20 itself. I suppose we could frame within that. I mean, we could bring forth the Part 20 references and make it clear that Part 20.
So it's only clearing members and swap dealers. But, I mean, it is possible that you could have somebody who is neither one of these entities that is of significant size to trigger the reporting, couldn't you?
Sorry.
So in terms of periodic reporting obligations of large positions, under Part 20, the requirements are for clearing members, swap dealers, and also DCOs have reporting obligations. There are certain record-keeping requirements that would be applicable to non-clearing member, non-swap dealer entities that have large positions. They're record-keeping requirements, and I believe that the way that the rule works.
Large trader rule, Part 20?
Part 20.
Yeah.
In terms of the record-keeping requirements for those entities, so these would be non-clearing members, non-swap dealers who have these record-keeping obligations, they are able to maintain those records generally in the form that they would in the normal course of business. So the thought is that if you have these record-keeping requirements, the burden shouldn't be too onerous. But in addition to that, just want to clarify that Part 20 applies to physical commodity swaps that have a linkage, either directly or indirectly, to a specified list of U.S.-listed physical commodity futures.
So somebody trading in the Métis wheat contract could be currently a non-swap dealer, a regional bank, for example, that could have a sizable position of a linked contract. How do we compel them to report? Is that the linkage, or does it have to be actually linked to the U.S. contract?
The linkage is to the U.S. contract. Okay. That triggers the reporting obligation under Part 20. And the view as expressed in the guidance, as I understand it, is that that linkage, the fact that these swaps are deemed to be economically equivalent to U.S.-listed physical commodity futures, that is a direct and significant connection to activities in the U.S. market. Anybody, my colleagues can correct me if I'm wrong, but I do not believe that under the futures large trading program, there is a concept of substituted compliance, for example. I think that the threshold is if you have the large reportable positions in the covered futures contracts, you are required to report under the futures large trader reporting regime.
Thank you. Sarah, have we shared the requirement for direct electronic access in the form and format with the EU, and have they agreed that this is fine in order to achieve substituted compliance?
Have we shared
have we shared the requirement that we're going to insist on direct electronic access without any legal barriers and insist on the same form and format?
Right. I think the best way to answer that question about direct unfettered access is to step back for a moment and explain just how much work we've been doing in this area with our colleagues internationally, both on a multilateral level and bilaterally, in terms of being able to get to a good understanding of access to the data, but then also you'll see reflected in the Path Forward document that went out yesterday morning that we do have certain issues around data, but generally speaking, we're working through those collaboratively with our colleagues in terms of being able to use that data in a meaningful way to be able to sort through, understand, analyze it, aggregate it where that's possible, and I think there is a broad understanding right now about issues related to that. We've had numerous conversations, and my colleagues, both at this table and behind us, can tell you about many of those conversations, and I think we're working through that.
But on the issue of direct electronic access, they don't have any problem as far as you're aware of.
That I am aware of, no. I think that the
saving the privacy laws.
Yes,
which is the answer I was looking
with
for.
the exception of privacy blocking and
Thank
secrecy
you.
laws that have been well documented. Yes.
Jonathan, can we talk a little bit about our legal and enforcement authority under the cross-border guidance as opposed to rulemaking? What enforcement and legal authority does guidance give us?
You might
Turn on
want to
your
push
mic.
your button.
Turn on your mic.
The guidance reflects the Commission's interpretation of 2I, and it also reflects a statement from the agency as to how it intends at this time to apply and enforce Section 2I. And the enforcement authority comes from the statute, from 2I, and also from the rules that would, the rules the Commission has already promulgated that would then apply based on the interpretation of Section 2I. So that's, but the guidance itself is not binding strictly. We couldn't go into court and, as a count of the complaint, list a violation of the guidance as as an actionable claim. But the guidance does tell market participants what the Commission's current views are about how 2I applies in the cross-border context, and the statute gives us that enforcement authority.
Susan, can I ask you to come back to the table? I forgot a question on data. There was a footnote. It was 472. I have no idea what it is now. It's certainly not 472 in the last two documents I was looking at, but it said swap dealers have to report to an SDR. We went through this with CME Rule 1001. Does that mean, are we going to revisit the same problems that we had before?
And again, Jonathan, you might want to turn off your mic. I'm just helping it.
I'm not sure I understand your question.
So before Rule 1001, where we said the clearinghouse could be the party reporting to the SDR, I believe an earlier footnote said that it was 472. It's not there anymore. It's changed. But it said that swap dealers have to report to an SDR. Are we going to have the same problem? Maybe you guys know what the new footnote is.
I don't know the answer.
Which footnote is it now, Susan?
I'm sorry, it's 501.
Is it 468? Because I'm reading 468.
No, it's on page 219.
I think Commissioner Mallia might be referring to what was now.
Well, perhaps we're not referring to the same thing, but yeah.
All swaps.
Yeah, it's on page 203, footnote 468.
Oh, all right.
The wrong document again. Things only a day old. Seems as though it's changed, but does this fix that issue?
I think, as this, Commissioner May, I think this looks that this is now clean. Yeah, because your point is it well taken that it shouldn't say swap dealer, because in those other circumstances it might be somebody else. So let's make sure, just if there's another footnote as well, that we just ensure that Commissioner Malia's what I'll call cleanup is addressed.
And I would also, footnote 501 also may have some bearing on this as well.
So if you look at footnote, Carlene and Susan, if you look at footnotes 501 and 468, and just ensure that what Commissioner Malia is suggesting.
Can I ask, on the timetable and process for substitute compliance, I guess this goes to Eric or Gary. Since Eric, I think you're reviewing the submissions thus far from which countries?
We've received submissions now as of this morning from all 6 jurisdictions where we have registered swap dealers. That includes the EU, Switzerland, Hong Kong, Australia, Canada, and I think, did I forget any? Japan.
And what is your timetable for reviewing those and making a determination on substitute compliance?
We received, the first one we received was in late April, but most of them have come in very recently. And so we're in the process of reviewing them. I expect that the reviews, it's a process of first the staff reviewing the submissions, developing an understanding of the regulations, guidelines, and laws of each jurisdiction that are referenced in the submissions, and then having conversations with, consulting with market participants and regulators in each of the jurisdictions. So that process, I expect, will take a matter of months.
And what role will the Commission play in that process?
My understanding is that as the staff works through the review of these submissions and comes up with recommendations for the Commission will then consider them and make a determination with regard to substitute compliance.
How will you brief the Commission, and if we have questions for the international regulators, how will we be in contact with them? And will there be an open meeting, other than possibly what Commissioner Chilton's going to organize through GMAC?
Can I make a suggestion? I mean, I think that each of the commissioners should be as active as they wish with Eric, times permitting, but with Eric, Gary Barnett, Sarah, and getting briefings and advice and sharing commissioners' advice to the staffs. This is ultimately a commission determination. So I think that should be welcomed, and I hope that Eric and the team, in terms of regulator to regulators, what many of the international regulators have asked is for there to be collaboration and ongoing consultation, which there will be naturally really spearheaded by Sarah, Gary, and Eric directly at the staff levels. But I think commissioners should.
Well, I want to make sure that there is a process, and if they want to come up with a process to continuously kind of update the Commission on what they're working on and where they are in terms of the submissions, because I think in some regards you're going to have some probably very disappointed regulators that believe they are equivalent and that might have a different outcome than they expect, and we will have a problem, and I don't want to be facing that at the 11th hour. I want to know it maybe in the 5th or 6th hour before we get to some deadline that forces us to make a bad decision or a rush decision, when none of this has to happen if we engage publicly and transparently.
I think that we're on a similar path, and to have regular updates, commission briefings or commissioner briefings, because it's within the Sunshine Act, but to have briefings in writing and in oral now that we have all 6, if Eric and Gary, you can come up with a process within the next 2 weeks, that's a real process that we all know, and how you're going to keep us updated on the 6 jurisdictions and your initial thoughts, and then as they are ongoing.
Sarah, I'd also recommend that you ask foreign regulators if they'd like to participate in some sort of dialogue, if they want to come defend their submissions or talk about their submissions. I think that would be very helpful to have an understanding of what they're thinking and how they execute their own regulations and where they believe they're comparable. So I would welcome that opportunity. So when you speak to them, please pass on that request.
Yes, we will do that.
Commissioner, the last question, I apologize, but Commissioner Ouen mentioned the no action letter that went out, I believe, yesterday regarding the risk management. Now, this is an indefinite letter of no action, which comes right before what Eric and everybody are working on to find comparability. And I know we're under, some deadline of some sort we've created, but why did we give indefinite relief when we're about to make a comparability determination going forward? And furthermore, this guidance requires us to review every 4 years all of our substituted compliance, yet this is a permanent kind of relief. So I'm trying to understand how this process works and when the commission gets to make a decision and when no action letters substitute for commission decision, and especially when it's permanent.
Can I try to address it? I think the document appropriately reflects, I apologize, I can't remember the page number, but appropriately reflects that such actions where foreign regimes are essentially identical be brought to this commission, and I can't remember the exact words, but that's the presumptive approach. This negotiation with Europe, this was an important feature of this negotiation that they requested, and we've done this elsewhere in other circumstances where we've done no action letters. So it was a part of it, but it's definitely the intention, and I think in the guidance, to do such things at a commission level.
Well, I think we've taken the no action process and what should have been limited relief, carefully chosen selective relief, and turned it into an abused process that is creating that is frankly creating regulation and undermining the commission decisions, frankly reversing some commission rules. And that's a dangerous precedent. And especially when you're in one document, you give us ultimate decision to make substitute compliance and then take it away through a no action letter. So I think, we definitely need some processes here and to understand when and how we're going to be using these things, because these are usurping the commission decision process right here.
Can I just add a statement? The guidance that's being considered for approval today acknowledges your concern about the use of no action letter, and it states that it acknowledges the concern that you just articulated. So it expressly states that going forward, any prospective essentially identical findings will be made largely by commission order, but we also retain the flexibility to do so through commission staff no action process. So.
So you say you don't like the no action process, but you reserve it anyway to protect our ability to do it.
I didn't say anything about not liking the no action letter process.
Well, I thought you said that you raised the same concerns I did.
No, I'm agreeing with your concern about inappropriate use of no action letter. I didn't say anything about whether in this context, as used in the essentially identical finding, was inappropriate. But we also have to, I think we all agree, that there is need for commission staff to retain the flexibility to use no action process to address certain specific situations. And I think when I say that acknowledge your concern, and it's reflected in the guidance, is that the commission commits to minimize the potential for abuse by committing to use the commission-level order as opposed to staff no action letter in any future findings regarding essentially identical?
Well, then,
Can I?
would it make more sense if we went, in this news release talking about the agreement with Europe, which is a positive? We list 2 other no actions regarding FBOTs and other things that we're going to be doing. Why don't we do those in either substitute compliance or a rule change?
Perhaps it would make sense for me to just jump in for a moment here and
Can you bring the mic closer?
Okay. To mention the specific letter that you reference does build off of a very close and collaborative and very constructive relationship that we have had with the European Union, and specifically the European Commission and the ESMA, the Markets Authority in Europe, to look at the rules that have been finalized under EMIR. So their statutory and regulatory framework, so that both the legal, the law, and the regulations, to do the side-by-side comparison of those rules. And I would compliment and thank very much our colleagues at both the European Commission and also ESMA for the work that they have done to basically be able to demonstrate to us, and we worked in discussions about looking at specific requirements, and they're reflected in that letter. So it's the trade confirmation rules, portfolio reconciliation and compression, documentation in terms of valuation and dispute resolution, and looking at rules that have been finalized under EMIR. And under Dodd-Frank, our rules in Part 23 for swap dealers and major swap participants, and recognize that they're essentially identical. And so when you have that sort of joint jurisdiction, that you can recognize that. And again, that's not inconsistent with a substitute compliance determination, which will occur in due course and has been.
It makes the substitute compliance irrelevant when you precede it with a no action letter.
It doesn't. I don't think it makes it irrelevant. I think they're separable concepts, both legally and intellectually.
What is if it's a commission decision and a no action? You've got dual path here that you could either do it no action or you could do it, in the guidance, the important guidance we have that is going to define how we deal with people internationally. It says that it's a commission decision through substitute compliance.
I think where we are today reflects the reality of the situation, and as we look at the markets, and we have 2 sets of rules that have.
Who looks at the markets? Who gets to make this decision?
I think the decision is being made, again, as we move forward. Well, at times, as Carlene was mentioning, I think we have the authority to use staff no action where appropriate. We also have the commission decision-making process, which we are all very much familiar with.
I would also note 2 things, Commissioner Maya. Often, and probably pretty consistently, regulatory bodies would want this commission to act as the full commission. So I think that, too, tends to that. This circumstance was one where the European Commission wanted us, at least at the staff level, to do something sooner than could possibly be done, but it's fully described and discussed in the guidance. Secondly, regulatory commissions, not just this one, have used staff no action letters probably for a few decades. When I was asked to chair this commission, one of the things Congress asked, the Senate asked, is could we inventory, and you remember this inventory of there's 700 no action letters that over the last 20 or so years, we couldn't go back 35 years, but probably over the last 20 years that we inventoried and put all on our website. That was 700 before. And yes, over these last 4 years, we've probably added another 100 to 150. But it is something that is a tool of regulatory agencies like ours.
Mr. Chairman, get your breath. 2 things. One, I almost chimed in on your previous concern, Commissioner O'Malley, about not learning about these things at the 11th hour. And I agree, we need, some process, whatever people come up with, whether or not it's showing us a list every week and telling us where people are, who's come in, sort of like we're doing on this CEF rule every week. They tell us who's applied, et cetera, so that we do find out ahead of time. But then to this point about the no actions, the no actions actually allow us, I think, to be more nimble and quick because it delegates it to the staff. Now, we can at any time say, hold on, we're not comfortable with that at all. It requires diligence on our part. But I think that will avoid, the no action process will avoid your previous concern about finding things out at the 11th hour about substituted compliance. So I guess it's in the eye of the beholder, but all of it comes back to the job that we're supposed to do to ensure that the appropriate authority is granted, designated to staff, but not too much at times if they're going astray.
Well, I'd be interested to know what I'm told that the no action process is just that, no action by the commission as well, and that we don't have a say. It's not a commission decision. Therefore, it's not subject to notice and comment. It's not subject to other things. So it does have a lower standard in terms of kind of the Administrative Procedure Act. So on one hand, it's a very nimble tool, but on the other hand, it is a end run around some of these transparent and rulemaking processes. We do have, in just Dodd-Frank alone, over 100 exemptions. 20 of them, I believe, are indefinite, which turns that into a rulemaking, in my opinion. If you say the rule is X and then say except for Y, and you make that indefinite, that turns into reversing commission action. That is a rulemaking in my mind, and that is probably something we need to be very careful with. And so we have a process. We're engaging with them. They're submitting it, and to turn on and off the commission's authority to use a rulemaking or a no action relief. I don't feel as comfortable with the no action relief, and I think we've crossed the line in how we've used them and the frequency we used them, especially in terms of how you understand what the rules and times and conditions, because it's not in the rule, right? You got to go to our website. You got to check it out. You got to go through the 100 or so ones that we filed, like, does this apply to the rule that I'm looking at in the Code of Federal Regulations or not? It's not as transparent. It's confusing at worst, and in some cases, I think it undermines the commission rules. So I'm going to leave it there for now. I'm not letting this thing go. The commission has a role. The president appointed us. Congress approved us to make these decisions. I've voted on hundreds of things. I'm around. I'm happy to vote on things. Put them before us and let us vote. But to have things taken away from us or not put in front of us and just provided indefinite relief or fixes is not a good policy in my mind.
What's that? Mark,
I don't have any questions.
I thank you all, and now I turn to Melissa.
This is a vote on the interpretive.
What's that?
Mr. Chairman?
Hold on, Melissa. I'm supposed to turn to you because these are two separate votes.
I thought we were separating them. I have one question on the exemptive relief.
Oh, I'm not. I haven't.
Okay, that's what I thought.
Yeah. This is a vote just on the guidance,
okay.
And then we will have a motion and a second on the second one. Yeah, and then after the motion and second, there'll be questions. So, if there are no further questions, I would like to thank the presenters, but now also ask if Melissa would, Ms. Juergens will call the roll.
This is a vote on the interpretive guidance and policy statement regarding compliance with certain swap regulations, also known as the cross-border final guidance. Commissioner Weejan?
Aye.
Commissioner Weejan, aye. Commissioner O'Malley?
No.
Commissioner O'Malley, no. Commissioner Chilton?
Aye.
Commissioner Chilton, aye. Mr. Chairman?
Aye.
Mr. Chairman, aye. Mr. Chairman, on this matter, the ayes have 3, the noes have 1.
Thank you. The majority or the ayes having it, the staff recommendation is accepted, and along with the technical corrections, which everybody will see as these hours proceed today and maybe into the weekend, will be sent to the Federal Register. I can turn over now to the second presentation presenting the cross-border phase-in exemptive order, and after you present, then I'll take a motion in a second and we'll have questions.
The staff is also recommending that the Commission issue an exemptive order which would provide temporary conditional relief from certain swap provisions of the Dodd-Frank Act to non-U.S. swap dealers and MSPs, as well as foreign branches of U.S. swap dealers. Among other things, the exemptive order recognizes that market participants may need additional time to facilitate their transition to the interpretation of the term U.S. person in the guidance. Under the exemptive order, the definition of the term U.S. person contained in the Commission's January order of last year will continue to apply from July 13, 2013, which is the date that the exemptive order is effective, until 75 days after the final guidance is published in the Federal Register. In addition, market participants may continue to apply the swap dealer and major swap participant calculation provisions contained in the Commission's January exemptive order from July 13, 2013 until 75 days after the guidance is published in the Federal Register. The exemptive order also would provide non-U.S. swap dealers and non-U.S. MSPs in 6 jurisdictions that have submitted a request for a substituted compliance determination with conditional relief from certain entity level and transaction level requirements until the earlier of December 21, 2013, or 30 days following the issuance of a substituted compliance determination.
We'll now entertain a motion to accept the staff recommendation on cross-border phase-in exemptive order.
So moved.
Second.
I support the exemptive order. And with this important step has been taken, I think, to provide market participants a time to phase in to this new market reality. I will have a longer statement of support, but the reason I support this, I think that it provides an adequate period of time, this 75 days from when it's in the Federal Register, added to the last year of discussions and dialogue with the marketplaces for the market to adjust to this guidance, but provides further time, approximately 5 months additional time, to work with foreign regulators in these 6 key jurisdictions. And I'm glad to hear, Eric, that as of this morning or last night, we did get the last submissions. But we've been working actively with Australia, Canada, Japan, and the European Union for some time now. And as Eric reported, we got there's one swap dealer registered from Switzerland and one from Hong Kong, and I gather we just received those. Is that right? It aligns with what at least Europe and Japan had asked for to proceed afoot, to proceed promptly, but to give an additional 5 months for dialogue, collaboration, to look at outcomes as is appropriate. But it does mean that, and it's after 3 years of Dodd-Frank having been passed and a year of discussion on cross-border, that I'm just going to use one example, but a hedge fund that has its principal place of business in the U.S., a nerve center in the U.S., but just happens to have a P.O. box in the Cayman Islands, should probably be getting ready to do their central clearing as a U.S. person come about 75 days after this is in the Federal Register, and I think that's appropriate. I also look forward to the comments that the public would send us on this exemptive relief. Commissioner Chilton.
I don't have any questions other than continue to thank you guys, but wanted to make one comment about the phase-in. I mean, it is the key component of getting this done in, I think, a more streamlined, efficient, and effective fashion. That without the phase-in, we'd be going not just first, and I don't mind going first, but we might be going first by a significant length of time on some things, and we don't have a real good visual on anything that might come out sideways. Would there be market migration? Would we be poking a stick in another regulator's eye? And so I think that the phase-in is really the core concept that allows us to go forward, even though we are going first, in an appropriate way that, as I said in my opening remarks, will lead to a better networking of global regulatory regimes. So again, thanks to staff, and thank you, Mr. Chairman, for including this concept, which I think is really key to moving forward. Thank you.
I thank you, Commissioner Chilton. I know that you called for this. In fact, all the commissioners called for this, but you happened to call for it in a speech about a month ago, and Commissioner Ouen then called for it in another speech. But I thank you for all your input, because I do think, this is consistent with really we've been consistently phasing in compliance, and it may well be even as we make substituted compliance determinations, and I think we will be making those, this commission might phase even some of those in further beyond this December date. This is really a date, to keep us moving afoot to make the substituted compliance determinations, but there may be phasing that I would certainly support beyond that as we phase in the substituted compliance itself. Commissioner Amaya.
Jonathan, Section 553C of the APA, 5 U.S.C. 533C, states in part that after notice required by this section, the agency shall give interested parties an opportunity to participate in the rulemaking through a submission of written data, views, or arguments with or without the opportunity for oral presentation. This is regarding the Administrative Procedures Act and a memo you sent me saying why my request over a month ago to provide a 15-day comment period was too narrow. Now we've gone to execute the order and have a simultaneous comment period, which does not seem to meet, because it says after notice required by this section. It seems, though, in your memo here, you said case law does not set a minimum floor for a comment period, although the Supreme Court in dicta has suggested it may view a 30-day as the minimum period for allowing meaningful opportunity to comment. Why did we go with 0 comment before the Commission decision?
Commissioner Amaya, this is an interim final exemptive order that provides for an opportunity for comment, a 30-day period for comment. Agencies do have the authority to issue interim rules, interim orders under the APA for good cause, and here believe there was a basis to do so in light of the.
Where did you put that for good cause? That discussion? I don't think it's in the. I didn't read it in the exemptive order. Why we?
It's on pages 6.
You might pull the mic closer to you.
Pages 6 through 8 of the exemptive order go through some of the reasons the Commission is issuing the order in this context, including the rapidly evolving nature of the legal regimes, and we've had, of course, the ongoing discussions with foreign regulators where the picture really has been changing virtually every day up until today, so there is. This really was a rapidly evolving situation. So we believe there's a basis in this case, in light of the perhaps that the substitute compliance program and is not perhaps as far along as anticipated before at this day, that to alleviate uncertainty in the markets and possible disruption in the markets.
I'm reading the first page in this, and it says, in this final exemptive order, the Commission provides temporary conditional relief effective upon the expiration of the January order. It doesn't say interim final anywhere.
Well, my understanding is it is an interim final order.
Don't say that.
No, I believe we'll have to verify that the Federal Register doesn't recognize interim final order, so it has the effect of an interim final order that it is.
The Federal Register does not recognize interim final orders? Because my next question was, where in the APA are interim final orders discussed?
When I say, well, I think we're sort of stuck on labeling here. The reason, if the question is why are we not calling this document?
I'm stuck on the comment period and what the APA provides.
Okay.
If you want to label it something different,
I thought the
just like to
question was
understand
why
what the
we're not
context
calling.
was.
Right.
Yeah, well, it's in whatever you title the document. It's in the nature of a rule, regulation, order that, where generally under the APA there are circumstances in which this type of agency action can be issued on an interim final basis.
I mean, you've listed for me in this memo why a 15-day was perilously dangerous in terms of APA, citing Hollingsworth versus Perry, legislative history on Administrative Procedures Act, Forster and Customer Protection Safety Commission, you know, a variety of things here, Florida Power and Light, all these other kind of things, and why, you know, a minimum comment period is necessary. So I'm concerned.
That's right. That was generally, that wasn't addressing the interim final authority that an agency has.
And so I suspect there's some court case around interim final, which we're on solid ground.
There are a lot of cases that have interpreted the authority of agencies to issue interim final orders, and we believe in the circumstances here it was justified, again, in light of the rapidly evolving nature of the legal regime, the novelty of that regime, the global reach of the swaps market and that regime, that there was a justification here to do that, and then to give 30 days for comment. And
but it's 30 days simultaneous with implementation, right? It's not a 30-day comment period and then implementation. It's implemented effective upon publication of the Federal Register and simultaneously accepting comment. There's no commitment that we will go back and answer the comment letters, is there, or change our rule? It's just a comment period, right?
That's right. It's a comment period.
We have no commitment to do any of the, digest it, put it before the commission again.
But I think we can assume that the commission will act in good faith and will take the comments seriously, and the comment period does close before the other dates set out, the other deadlines set out, which, for example, substitute compliance in December. So we'll have the comments well before that time that the commission can consider.
Can you provide me the case law when you get a chance on this to support the interim final guidance strategy? And you might want to relabel this thing because it doesn't say that today.
Okay.
Commissioner
I'm sorry. We at commission requests, I remember even discussions with probably at least two of you in December. We did this similarly around business conduct application of external and internal business conduct rules that we did what I would colloquially call an interim final exemptive order there, providing 4 months and 6 months time for phasing in the compliance, to do it as a commission action, to have the commission speak as a commission rather than no action letter, back to the discussions earlier. And this is very similarly to provide the markets with clarity and confidence that they have this relief as a full commission action, not not dissimilar from what we did in December on that one.
I'm for clarity and certainty and transparency, but we've got to abide by the laws. And APA is not something you get to ignore. We are an administrative agency. We have to follow that law.
And we are following that. Susan?
I just wanted to point out, to the extent it's helpful, Commissioner O'Malley, that interim final rules are also not specifically mentioned in the APA. They are a creature of agency action that developed in response to a particular need. This interim final order appears to me and to all of us, I think, to be an analog to the interim final rule. It follows the same process where the action becomes final when published or when voted on, however that works, with a comment period to follow, so that if there are egregious errors that need to be addressed, they can be addressed after the fact. That's all. Thank you.
Commissioner Ouen.
I don't have any questions.
Then I think, let me just make sure I read the script properly. If the commissioners are now prepared to vote, Ms. Juergens, will you please call the roll?
This vote is on the exemptive order regarding compliance with certain swap regulations, also called the cross-border phase-in exemptive order. Commissioner Ouen?
Aye.
Commissioner Ouen, aye. Commissioner O'Malia?
No.
Commissioner O'Malia, no. Commissioner Chilton?
Aye.
Commissioner Chilton, aye. Mr. Chairman?
Aye.
Mr. Chairman, aye. Mr. Chairman, on this matter, the ayes have 3, the noes have 1.
The ayes have it, and the staff recommendation is accepted, and along with technical edits, will be sent to the Federal Register. Before we adjourn, I just wanted to mention, as often Commissioner O'Malia asked me, so I was anticipating what's next, and it's always a terrific question. I thought I would just mention some of the things that we currently have in front of the Commission that hopefully we will finish up this summer. Commodity pool operator harmonization final rule. This was a matter that we proposed. I see Amanda O'Lear here, but we proposed about a year and a half ago, and the final pens down version, I think, has really benefited from each of the commissioners' offices. I don't know if there's further input, but if there is, it would be terrific to get that in, and whether we can move that by seriatim promptly, or if you all think it's appropriate, we can have a public commission meeting to do that. There's the final, is it called exemptive relief for cooperatives, which I think will move on promptly. There's also something that is very important to the Europeans, and though it was not put in the joint statement for various reasons, but that's we move on systemically important clearinghouses, these provisions of covering the 2 largest of their members if they were to default, and something called 2-hour recovery time. I think those are the 3. I might be mistaken that are in final shape before us. Right now, we do have some proposed or finals as well. We have a proposed on position limit aggregation that is in front of us. We're still working. I think all the commissioners have that, but we're still working, and I'm looking forward to the Division of Market Oversight, the Office of Chief Economist, and Office of General Counsel to sort of hopefully promptly in the next few weeks to get something to the commissioners to consider on proposing on position limits. And I look forward to, I'm going to look at Gary Barnett and the Division of Swap and Intermediary Oversight, and obviously working with the Chief Economist and General Counsel and clearing and risk on customer protection rules to move that up in front of us. And I think there's also in front of commissioners the concept release on, I sometimes call it testing and supervision, but I can't recall what we label that. But and I know that we made very good progress between your office, Commissioner O'Malia, and the Division of Market Oversight. I don't know if it's all looped. Almost. So hopefully when Commissioner O'Malia and Commissioner Chilton tell me that it's there, we can do that. That would be terrific. And there's something on ownership and control. And the ownership and control is, to finalize that rule, I'm just making a plug for it, but it really is important for surveillance, and I think it's it really works together with all that you've done in the Technology Advisory Committee to go from paper to data. I think that's an important one. I may have missed one or two. In the near term, we continue to work with our fellow agencies on the Volcker Rule. And that one is so many other agencies, the Federal Reserve, the FDIC, Office of the Controller of the Currency, the SEC, Treasury's involvement. But to the extent commissioners have input, I don't have a full document, or staff I don't think has a full document unless anybody in the room knows, from the other agencies. But if there's input or thoughts and considerations, I think it'd be helpful. And maybe we should feed input from all of us back to the other agencies on the Volcker Rule. So those are some of the things. I don't know if Commissioner Chilton, Amalia, or Weejan have anything you want to add on that.
Thank you for mentioning limits, and I agree and appreciate you pushing to get that done. I want to get limits done. And then for, we've talked about the Volcker Rule, but I think on Volcker, this agency has a really key role, because I continue to be concerned that the exemption for proprietary trading that's allowed under the law could be, it could be a huge loophole if we don't define what hedging is. And so I hope that we do either individually put something forward, or even perhaps as a commission, if we can agree on. I mean, we know something about hedging. Hedging are us. So it seems to me that we should, re-engage. I know we've been involved in it. We've been focusing on some other things, but I look forward to doing that and work with my colleagues on it.
And I thank you, Commissioner Amalia, for always spurring me to do this. With that, I think I will take a motion to adjourn the meeting.
So moved.
Second.
I want to say the meeting's adjourned, but first I want to give a big thank you to this incredible staff that pulled this together. So I thank you, and the meeting is adjourned.